Welcome to Power and Politics. I'm Eric Lance-Crunner. New Jersey Senator Bob Menendez goes on trial Monday, accused of corruption and bribery. Joining me right now with insight on what we can expect as this trial gets underway is Rocco Cipparone, former federal prosecutor in the District of New Jersey and an adjunct professor at Rutgers Law School. Rocco, it's good to see you again. Thanks for being here.
Good to see you, Eric. Thanks for having me.
Listen, let's start with the jury selection process begins Monday. How difficult do you think it's going to be to seat a jury, especially given the prior allegations, the hung jury that we just mentioned?
I mean, that's going to be the first line of concern for both sides, in particular the defense. They're going to want jurors who have not heard about the prior charges against Menendez, even though it was a hung jury and there was a prior investigation that went nowhere. That's going to be hard to ferret out. There are sometimes stealth jurors who want to get on a jury. The hope is, though, that with other things that have been taking kind of more precedence in the news, maybe because they're in New York, there'll be a little bit less pervasiveness in terms of the knowledge of potential jurors of what happened in the past with Menendez. But that is a primary concern for both sides, in particular the defense.
So what kind of questions would you be asking prospective jurors?
Well, in federal court, the judges often tightly control the questions that can be asked. We often submit written questionnaires to the judge, and they'll take bits and pieces from each party's, and then they'll let you follow up with individual questions. If I were looking at it, I'd want to know what, if anything, they had heard in the press about Menendez, positive or negative. I'd want to know their views on loosely termed political prosecutions. I'd want to know their views on whether they heard anything about the charges against his wife. And any of the past investigations. They're really going to be the central focus for the defense, in my opinion.
So you alluded to this a moment ago. Does the fact that this is going to be happening, the venue is Lower Manhattan rather than New Jersey, perhaps aid in seating a jury in a more expeditious manner?
It might, because again, if this were in his backyard, for example, meaning in New Jersey, there's certainly going to be many more people who are aware of it because he's their senator. Unfortunately, he's one of many politicians at the federal level now charged with different crimes. So a little bit of his media attention might have gotten lost in that shuffle, and that might make it easier to get a jury. So between the venue and the other things that are happening in the media, there's a possibility it might go a little more quickly because of that.
So let's talk about the case against him now. This is allegedly a massive multinational influence peddling scheme here. The Menendezes are accused of everything from accepting lavish gifts such as gold bars, including nearly hundreds of thousands of dollars in cash as well, mortgage payments, a Mercedes, to benefit three businessmen, Fred Davies, Jose Uribe, Wael Hannah, and the senator's accused of accepting bribes to secretly aid and act as a foreign agent as well of Egypt and to aid Qatar. So let's talk about this. Which are the most difficult, do you think, difficult charges to prove here, and what do you think would carry the most weight and the most severe consequences?
So I'll take those in reverse order, if that's okay.
Sure.
The ones that the charges that carry the most severe potential consequences are what we call an honest services fraud scheme. That is depriving the public of his honest services as an elected official. That carries up to a 30-year statutory maximum sentence, which is by far among the charges the greatest potential sentence. The other charges range from a low of 2 years maximum to up to 10 years maximum. Now, that being said, there are things called federal sentencing guidelines that get assessed after someone's convicted, and that will much more restrictively constrain the range of sentences that are at least suggested as advisory to the judge. It won't be a 30-year sentence, but that's by far and away the most significant charge. It might also be somewhat of the most difficult to prove because what prosecutors have to do to prove that charge, whether it's a bribery or the deprivation of the honest services, is couple his actions and the money payments with the exercise or planned exercise of his influence. And Menendez's defense is going to try hard to uncouple those things and try to challenge the prosecution's evidence on whether there in fact was a quid pro quo. The government really has to show that payment A was for action A. And that's not always easy to do. It's often done clandestinely if it's done at all. And so that's going to be the most significant hurdle, I think, in the government's case.
Rocco, this week, Senator Menendez said that he plans to be present in court for all days of the trial. And when asked if he plans to take the stand, he said that's to be determined. Do you think he will?
That's a really risky thing for any defendant to do. So it's really risky because the prosecutors here have a wealth of information about Menendez. He is likely, if he gets on the stand, to open what we say is open the door Two, information about his past conduct coming in as it affects his credibility, and that's really dangerous for him. So I think unless he's way behind on points and figures that he needs, for lack of a better term, a Hail Mary pass, he's probably better off staying off the stand, because it is very difficult to withstand sustained cross-examination. And I would expect if he gets on the stand, he'll be there for days. So I don't think he will. I also was surprised to hear him say that he would attend the trial, I think I read, as his schedule permits.
Yeah.
I think that'd be a mistake. I think he should be there every day, signifying to the jury how significant this is in his life, and it's the central thing in his life.
As you know, Jose Uribe struck a plea deal with the DOJ. As a former federal prosecutor, would the U.S. Attorney's Office agree to such a deal if they didn't think that Uribe could significantly help them and could help them win their case?
Look, clearly Menendez is the #1 target in this case. And the other players, while significant in terms of the allegations against them, become less of the focus as this proceeds to trial. Menendez is the one with a real big bullseye on his back. So it's very common to make a deal with somebody, even if you think their testimony could be marginal. Here, I'm sure they think that his testimony is very directly on point and relevant. And I'm sure they've spent hours and hours, if not days, preparing him for that testimony. That being said, I'm sorry.
No, please, go ahead.
That being said, I'm sure the defense has spent equal, if not more, hours ready to cross-examine him about his motivations for pleading guilty, and more importantly, for becoming a cooperating witness with the government, his motivations and his likelihood to lie from their perspective, to fabricate or embellish, and his self-interested nature of his testimony, because he's looking for a sentencing break. So it's always a double-edged sword for the prosecution. It does tie a nice bow around things that otherwise might be simply an inferential argument, but there's a saying that sometimes in different iterations defense lawyers use, which is if you lie down with dogs, you wake up with fleas. And I'm sure the defense will make that argument.
We're almost out of time, but you and I have spoken before about how having to try this case separately from the Nadine Menendez case is a nightmare scenario for the DOJ. Do you expect that the senator will incriminate his wife?
Well, at least in earlier filings earlier this year, he intimated, at least if not even directly indicated, that he was going to, in some sense, implicate his wife by arguing, at least inferentially, that he was unaware of her activities and he was essentially kept in the dark of those activities by his wife. That is going to create some tensions, by the way, with his co-defendants, because there's an inferential suggestion that they were in a conspiracy with her and he was the least knowledgeable person. So that's always a difficult thing when you're in a joint trial with other defendants. But I do think that's one of his potential strategies.
Rocco Cipparone, thank you so much for your time. Pleasure talking to you as always.
Eric, great to see you. Pleasure. Thank you again.
And keep it right here. Power and Politics continues right after the break.